Welcome to another masterclass. If you are joining me for the first time, make sure you hit that follow button right now on Facebook at Rosetina Rahamin Pearls. And head over to YouTube to subscribe to Legal Opinions with Clementina. You don't want to miss the deep legal and relationship insights we drop here weekly. Now, let's get into today's matter. If you are a contractor, a consultant, or a creative, let me ask you a question. Have you ever sent a detailed invoice to a client? They replied with received, thanks, or we will process this, but later turned around to say, wait, we didn't actually agree to these terms. If you think you have no case just because they didn't sign a formal contract on a dotted line, you are legally mistaken. Grab your pen. Today, we are talking about the law of silence. In commercial litigation, there is what we call Estoppel by conduct, or the principle of invoice acquiescence. When you send a formal invoice outlining your fees, scope of work, and payment deadlines, and the receiving party accepts your services or replies with an acknowledgement without objecting to the price within a reasonable time frame, the law considers that silence as acceptance of the terms. They cannot consume your hard work in the morning and then try to renegotiate the price in the afternoon. Their failure to object when they receive the invoice legally binds them to that value. But listen to me closely. Protection is a deliberate act. To lock this trap tightly around a defaulting client, your invoice must do the heavy lifting for you. Stop sending naked invoices. From today, every single invoice leaving your desk must carry this specific silence clause at the bottom. Payment or failure to object to the terms of this invoice within 48 hours of receipt constitutes total acceptance of the fees and conditions stated herein. Don't turn your professional services into a corporate situationship. If they don't object to the bill, they have agreed to the debt. I am Ambassador Clementina Iukiri, de Dominus Litis.